A becomes surety to B for C's conduct as a manager in a bank. So there is first of all a contract between B and C. This is the original contract. This contract between B and C will define the terms of the employment. It is B's bank, so B is the employer and C is the employee as a manager. There is a contract between the bank and the manager, between B and C, as to what is to be paid, what is his job, etc., etc. This is the original contract. And then there is a contract of guarantee between A and B. This is the second contract, the contract of guarantee. A becomes surety to B. So A now becomes the promisor, B is the promisee, and he is surety for what? He is a surety for C's conduct as a manager. So if there is any default by C in his conduct as a manager, and if any loss is caused to B, the banker, then A becomes liable because he is the surety. Now this is the position as it prevailed, and thereafter there is a contract between B and C, another contract, in which A's consent is not taken, and according to this new contract between B and C, C's salary shall be raised and he is made liable to 1/4 of the losses on overdrafts. Now earlier he was not liable for any loss on the overdrafts. The only thing he was liable for was his own conduct. If he conducts wrongfully, then of course C is liable and also A became liable because he stood as surety. But in his normal conduct as a manager, he is not responsible or liable to share any loss which the bank suffers on account of overdrafts. But now, with a renewed contract, he assumes the responsibility in respect of 1/4 of such losses. Now, since this variation in the contract between B and C has been made without the guarantors, without the surety's consent, surety is not responsible for this loss which C has additionally assumed.